it's the 24th of January, 2025, and we are going to be talking today about the flip-flopping policies on open work permits for family members of workers in Canada, workers and I guess students as well, the spouses and family members of students as well. So before we dive into the topic, we want to give you a bit of a backdrop in terms of how this has gone historically, just to give you a sense of how much this field has flip-flopped back and forth over the years. So initially, it was the case that the spouses of skilled workers could come into Canada on an open permit. So that meant anyone above, the OA and Bs when the NOC was looking at OAs and Bs and the tier zeros and ones. Is that what they're called, Steve?
Yeah, tier
Uh,
0, 1, and 2.
when they 0, 1, and 2, when they went to the new NOC classification system.
Oh, and 3. Tier 0, 1, 2, 3.
0, 1, 2, 3. They were able to get, if their spouse was on a work permit, they were able to get an open work permit of the same duration. So those couples could stay together and their children would be able to accompany on visitor records or study permits. Low skilled workers, so in the lower strata of the NOC classification, they were not able to bring their accompanying spouses unless that person qualified independently, that spouse. So that's how it was historically.
Yeah, I'm just going to expand on that. So for people who don't
Yeah,
know what you mean by like the knock and everything.
sure.
So all jobs in Canada are classified by the Department of Employment and Social Development Canada into what are called national occupation classifications. It's these knocks, as they're called for short, are pretty much the basis for the entire foreign worker program as well as economic immigration.
And
And
employment insurance, like that's where
yeah,
they're
oh
tied
yeah,
together.
another non-immigration areas, but it forms kind of the bedrock of Canada's immigration system. And what distinguishing between knocks becomes very, very important when people are applying to immigrate or get work permits. And these distinction between skills can sometimes seem a bit arbitrary. So, for example, under the old system, an administrative assistant would be classified as skilled, so their spouse or common law partner could get an open work permit. An administrative clerk would be classified as unskilled, and their spouse or common law partner could not get an open work permit.
Mhm.
And that for, well, as Deanna will get into the history again, that for decades was the basis of who could get an open spousal work permit, whose spouse could join the principal applicant in Canada and work.
And there are many consequences arising from these finer distinctions of what knock you fall into, and what you might have a blend of skills from one knock and from the other, and is more than 50% in a higher skilled occupation or in a lower skilled occupation. So again, we could have an entire session on the knock, but let's just stick with this issue of the spousal work permit. So essentially, there was a very clear distinction between the privileges and rights of the spouses of skilled workers and the spouses of low skilled workers. So as a result of a lot of advocacy, eventually they decided, you know what, we're going to give the same rights and privileges to the spouses of low skilled workers so that there's not some families get to stay together and other families do not. And so Steve will remind me, when was that
Yeah,
policy?
December 2022. And I'll quote the rationale. I've got the
Hmm.
press release in front of me, and the rationale for the announcement, as in the news release, reads, quote, prior to this announcement, spouses were only eligible for a work permit if the principal applicant was working in a high-skill occupation. This new temporary measure aims to improve the emotional well-being, physical health, and financial stability of workers by keeping families together. As a result, it is expected that the worker will better integrate into their overall work environment and community, end quote. It also says elsewhere that the expansion of who could get an open work permit was done to address labor shortages.
Hmm. Okay, that's great. And I'll just say, like, I mean, for example, working in the caregiver field, you would often see a caregiver would come in, they would work for a period of time. The whole intention was that they would eventually qualify for permanent residency. But let's say for a 6, 7 year period, they're raising Canadian children, never seeing their own children. Their marriage breaks down. By the time the kids come, the kid's angry at mom, the relationship is broken down. And so then the cost of that broken family ends up becoming a consequence. So, I mean, again, all these sorts of things is what motivates a change in policy and now says, yes, spouses of low skilled workers can have their spouses and children. So
There
that's,
was also that rationale that the lower skilled workers typically would earn less, so it would be very helpful if they had a partner who was here who could work.
well, this is my mantra that they need their second income more because, like, they can't afford to go back every weekend. They can't, or every month. They need the second income, and they can't afford to run two households on either sides of the globe. So it made perfect sense to me as a, like, working with the lower skill community. Anyways, enough said there. But that's happened December 2022. Okay, so fast forward to the the fall of 2024 when they start saying not all spouses and family members. Oh, didn't when did the rule come, Steve, where the dependents
The
of skilled
children,
worker could get work permits even in some situations? Was that
same time, was the
same
same
time?
time. The
Okay.
adult children. It was basically, and the only exception was farmers. Their spouses weren't allowed. People who would be working on farms under the seasonal agriculture and agriculture programs.
Even agri-foods and stuff like that, or just the
Yeah.
SOP or
Yeah, so it's
okay.
pretty much everyone but them.
Okay. So then in the fall, they started saying, no, we're going to change this again. And we are intending to make it so that only certain high skilled workers are going to be able to have their spouses and family members. There was no specificity. There was just sort of teasers, just everybody, this is coming. This is coming. This is coming. But with no specifics. And then the announcement came, what was it, last week?
January 14 was the formal announcement. I'd been tweeting that there were briefing notes presenting different policies with various degrees of redaction. But yeah, the official announcement came on the 14th.
14th. And then and then it became effective as of the 20.
Yeah, it became effective as of the 21st, with, in typical government fashion, the final rules being announced the day that it took effect.
Right. So yet another situation with immigration lawyers, not even just lawyers. I shouldn't be worried about the lawyers as much as the people who are affected, scrambling to be like, oh no. And so the rules themselves are a bit complicated, but
And stricter
essentially
than they were before. But you
stricter
not
than they've
just
ever
before,
been.
yeah, stricter than
Yeah.
they've ever been. Well, at least like in the modern immigration era.
Yes. So now, in a nutshell, in order to qualify for an open permit, first of all, the principal applicant, like the original worker, the one who has a work permit, needs to have a work permit that is valid for 16 months, or is it 18 months?
16.
16 months.
16 months with the rationale not being discussed in the news releases, but in the briefing notes that I obtained. The rationale is that the work permit will be valid for 1 year, and they are assuming a 4 month processing time.
Okay.
Yeah,
I don't think that the processing time is actually 4 months, but
probably depends on the visa office.
all right. Okay, so there's that. And then also, it is no longer available to low skilled Knox at
Yeah, not
all.
just low skilled knock. So it's limited to tier 0 or 1. And
Mm-hmm.
then there's this list of tier 2 or 3 occupations. And that was what came out on Tuesday, was the actual list of which tier 2 or 3 occupations. These are the occupations that, kind of pertain to trades, program or occupations that the government would say requires a diploma. And it's just this long list of occupations in natural and applied sciences, construction, healthcare, natural resources, education, sports, and the military.
But also some weird ones that like coaches, like I mean, there's just not to say that they shouldn't, but it's just like looking at it wouldn't necessarily be like, oh, that's totally this is a coherent, this makes
Oh, you
perfect
gotta have
sense to me.
sports. You gotta have sports.
Okay, there you
We
go.
got hockey teams here.
Right, of course. So yeah, this is what we have now. It is effective already. And so there are some weird, like we won't go into the minutia. There are some weird carve outs and exceptions for people who are already on permits and can they extend and all of this sort of thing. But this is
Not
the new world
easily.
order.
But yeah,
No,
not easily, which was one of the surprising things, was that extensions, unless someone's applying for permanent residence, existing workers on open work permits could have trouble extending their permits. And given that permanent residency is hard to obtain right now, there's going to be some families in Canada in very uncomfortable situations. What are your overall thoughts?
my first thought is what happened to those outcome, like those regulatory, they weren't regular. Was it a regulatory impact assessment that led to the December 2022?
No, it's a PDI, a public program delivery update.
Okay, so, but in December 22, the opinion was that this led to better outcomes and better integration and better outcomes for the workers themselves. I don't know why that ceases to be the case in January 2025, or
They
if
have
just,
not said anything. They didn't even do a news release when they did the most recent changes. It was just a notice. I've been
yeah.
asking the same, like, that's basically where I fall.
Yeah. And also why still, like I understand that I guess, I mean, I think we can speculate that the department just wants to be nicest to the workers that they like the best, but it's certainly not about who actually needs their spouse and their children more
Yeah, that's the irony of it all is that the workers who most need the extra family income
and who
aren't
can
allowed to
least
have their
afford.
spouses work on open work permits, while those who argue about, or those who have higher wages, their spouses can work. Those who have lower wages, their spouses are prohibited from working, which causes all sorts of issues about how they'll afford to live in Canada. Can they afford to live here that are pretty obvious, and I don't think we need to discuss fully.
Yes. I mean, I think we've started these exchanges, you and I, Steve, like offline, well, I mean, not offline, but off public, where
Yeah.
it's like, so what's the reason for this? Malice, and I'm sort of like more and more often I'm thinking, so what is the reason for this? Well, they just don't want any low skilled workers anymore. And so rather than just saying we're not open to low skilled workers, they're making it like impossible for that to be a viable place and hoping that just people won't arrive. The other thought that I have about this is that I think it's going to have a similar effect also on the ones that they actually do want. Because, and this is the thing that I've been going on and on about damaging the Canadian brand, because those that are in the so-called like desirable immigrants, um, there's just so much uncertainty, like for reasons that we have discussed, like this kind of policy being passed. There are going to be push along impacts. Like I'll give you an example. Let's say, the CEO of whatever company doesn't get an 18-month work permit or 16-month work permit because their passport is expiring. And then they need to extend their work permit, and their spouse didn't apply at the same time because they weren't ready. They were studying abroad or giving birth to a baby, whatever. And now the principal applicant needs to renew their work permit inside of Canada before the spouse can apply. So they're waiting 5 months for their extension to come through before they can, like, it's just all this crazy
Hmm.
stuff. So it's like, I understand that maybe you're just saying none of these people. But again, Canada's doing these things. They're not being honest or straightforward or direct about what they're trying to accomplish. And instead, they're building a bureaucracy that is nonsensical and defeatist, and so everyone feels like they're in this Kafkaesque process and nobody's going to want to come.
And the other thing, and this ties in, and maybe my last big thoughts on the topic are, as Ryan Rosenberg actually at work was pointing out, a reason to get open work permits is that it can make getting a bank account easier. It can make getting documentation easier. But also, as we mentioned a few podcast episodes ago, if they're not getting open work permits, they will typically be getting visitor records, those whose spouses accompany them. And as we discussed, visitor records, the latest interpretation from the department is that they are canceled when someone leaves Canada. So unless the department, and if anyone in the department is listening, like it's very important to kind of reconcile this right now, as you've got on the one hand, the department saying more and more people are going to need to be in Canada on visitor records. You have CBSA saying they don't want to print visitor records. And then on the when people exit and re-enter all the time, and you've got IRCC saying those who exit and re-enter, their visitor status expires after 6 months because the visitor record is canceled. And it's tough on you that CBSA wouldn't print a new visitor record. And then you have the letters where children are being told that they've overstayed and need to leave. And by the way, since we recorded that episode, a few people emailed me to say that they heard our episode. They initially didn't believe us. They contacted IRCC, and IRCC told them, we've looked at your situation. Yes, you and your spouse are fine with valid work permits. Your children's visitor records were canceled. They've been here illegally for a year now, and you either need to leave Canada or they need to scramble and apply for temporary resident permits before
Good
enforcement
luck.
action is taken. So if the government is going to be taking the position that less people can get open work permits, this issue with visitor records being canceled really needs to be sorted out,
Especially because if the motivation is to prevent needless work, it's not going to prevent needless work because everyone's
right?
going to be insisting, I need a visitor record. And I think like human resources departments, employers, they're scrambling to maintain compliance. But how are they supposed to know when their employees' family members are going to become non-compliant? Because like every time they cross the border, you need to tell us, you need to send us the new visitor record,
Hmm.
it's very, very difficult for anybody to maintain compliance for, people are really trying, they're really trying, but I think that the landscape is changing so much that, we're having a hard time following the mark.
Yep.
I think that's all
Awesome.
I wanted to say. Yeah.
Yeah. Well, I mean, I think we'll see how long these new measures last and how long they're in place for. And I'd love it if they actually like were ever asked what happened to those rationales,
Yeah.
as I don't think they've been asked. And it would just be great if somebody were to ask, what happened to the whole idea that families, workers are better able to integrate and everything.
Well, bookmark to us. If Mark Miller ever comes onto our podcast, this will be our first question for him.
Exactly.